afternoon, or good morning, depending on where you're joining us from today. My name is Kelly Roscom, and I am the Director of Law and Policy at the Center for Gun Violence Solutions at the Johns Hopkins Bloomberg School of Public Health. And I have the distinct honor of moderating this webinar, The Supreme Court and United States versus Rahimi, the Risk of Armed Domestic Abusers. Thank you so much for joining us today. During our time together, we're going to be discussing the upcoming Supreme Court case, United States versus Rahimi, which will decide if the government, consistent with the Second Amendment, can prohibit people subject to domestic violence protective orders from possessing firearms. We are joined by three expert panelists who will discuss the legal implications of the case, the data regarding the dangerousness of armed abusers, and how individual survivors experience firearm intimate partner violence and what this case means for them. I'm going to introduce each of our panelists. They'll speak, and at the end of our time, we'll have Q&A. So please make sure to type any questions you may have in the Q&A box. I'll be giving some periodic reminders about that. Our first panelist is Natalie Nanasi. She is an associate professor at SMU Dedman School of Law. She is also the founding director of the law school's Judge Elmo B. Hunter Legal Center for Victims of Crimes Against Women, where she teaches and supervises students representing survivors of gender-based violence in a broad range of legal matters, including humanitarian immigration claims, family law matters, and post-conviction relief, and oversees students' systemic advocacy efforts that aim to both prevent and seek long-term solutions to the problem of violence against women. Professor Nanasi's research explores the intersection of gender and feminist theory with immigration and firearms. Next, we'll hear from Shannon Frateroli, who is a professor of health policy and management at the Johns Hopkins Bloomberg School of Public Health, where she serves as core faculty with the Center for Gun Policy and Research. Her research focuses on policy strategies for preventing injury and violence, particularly firearm injuries. Her work to advance policies that temporarily remove guns from people who are behaving dangerously and at risk of committing violence through extreme risk protection orders and domestic violence restraining orders is one example of her research and practice work. Finally, we're going to hear from Ruth Glenn, who is the President of Public Affairs for the National Coalition Against Domestic Violence and National Domestic Violence Hotline. Ruth has worked and volunteered in the domestic violence field for over 29 years and holds a master's in public administration from the University of Colorado, Denver, program on domestic violence. Ms. Glenn has served on many domestic violence program, funding, and grant administration boards, provided hundreds of presentations on domestic violence victimization and survival, testified before the Colorado State Legislature and the United States Congress, and provided consultation, training, and technical assistance on a local and national level on victim and survivor issues. As a survivor, Ruth also often shares her experiences to bring awareness about the dynamics of domestic violence. Her memoir and call to action on domestic violence, titled Everything I Never Dreamed, was released in October 2022. So without any further introductions, I'll turn it over to Professor Nanasi.
Thank you, Kelly. I'm so happy to be here with you and my wonderful esteemed co-panelists. So I have a bit of a Herculean task today because I've been asked to cover in 7 minutes what a protective order is, what the laws are that impact protective orders and firearms, and what is going on here in the Supreme Court in the next week or 2 weeks from now. So I'm going to do as much as I can, probably stay at a very high level of generality here, and reserve to, happy to get into the weeds in the Q&A if people have questions. So let me start with, what is a protective order? So a protective order is a remedy that a survivor of intimate partner violence can initiate when they need protection from abuse. The specifics of it really vary from state to state, but a protective order will last about 2 years. And really importantly, a judge has the discretion to order relief that is specific to that survivor's needs. So that means that a judge can order an abuser to stay away from a survivor, from her home, from her workplace, order the offender to refrain from contacting or harassing or threatening the survivor, and significantly for our purposes today, can order that particular abuser not possess a firearm or purchase a new firearm as long as the order is in place. A protective order is a civil remedy, but it has very strong links to the criminal justice system, and really in two important ways. The first is that there's criminal activity that is at the core of a protective order. And by that, I mean, in order to get a protective order in every single state in this country, the survivor has to show some kind of offense that has happened to them that could be criminal in nature. So either physical abuse, something like stalking, harassment, or threats. That's going to be the conduct that that needs to be shown in order to get a protective order. And there are also criminal penalties that will accrue if a protective order is violated. There's some language in the Fifth Circuit Court of Appeals opinion that is the case that the court rather that decided Rahimi before the Supreme Court, that suggests that a protective order is, only civil, and that the courts are handing them out, really to anybody that requests them, that there are no protections in place for people who are respondents in those cases. And I think it's just really critical to say that that is absolutely not the case. So a protective order is really like any other civil case. So imagine a personal injury case or a contract dispute where there are very robust due process protections in place. So the respondent has to have notice, has to be served. There's an opportunity for a hearing. The rules of evidence apply, and the person who is seeking the order, the survivor, has the burden of proof and has to justify its entry. So in fact, protective orders really are not easy to get, contrary to what we hear people out there, and sadly the Fifth Circuit saying. And very importantly, the last thing I'll say about protective orders is that they work. I will leave the data to the experts, but just suffice to say that that the data show that protective orders are really effective at reducing intimate partner violence. So we'll hear again a little bit later about the dangers to survivors when abusers have guns. But in recognition of really how dangerous it can be, the federal law that is on the books right now still is that all felons, including felons, people who have felony domestic violence convictions, people who have misdemeanor domestic violence convictions, and anyone who is subject to a domestic violence protective order is prohibited from possessing a firearm. Importantly, it's not relevant to the case that the Supreme Court is going to hear early next month, but it's important to also know that about half of the states in the US have roughly comparable statutes as well. These laws have been on the books for decades, and until this year have survived every constitutional challenge that has been thrown at them. There have been challenges based on the Second Amendment, the Fifth Amendment, the Eighth Amendment, the Equal Protection Clause, the Commerce Clause, the Ex Post Facto Clause, and in every single instance, federal courts have held that laws that disarm domestic violence offenders are constitutional. I'll also add again, just as a brief footnote, that these laws, while incredibly important, are very challenging to enforce, but that is a conversation for another webinar that maybe we could schedule after this one. So what is going on at the Supreme Court? And let me actually back up a little bit and give a moment of history and talk about what's happened in the past, because the story doesn't start now. The story actually starts in 2002 when the Supreme Court decided a case called Bruin. And Bruin really fundamentally changed the approach to determining the constitutionality of gun laws in the United States, and really not just those that deal with domestic violence, but really any firearm regulation. And what the court said in Bruin was that only regulations, and I'm going to quote from the court directly here, that are consistent with this nation's historical tradition of firearm regulation are constitutional. So what that means in practice is that in order for a law today to be constitutional, there has to be some sort of historical precedent for it. Which, as you can imagine, might be tricky, because there were the world that existed in 1791 when the Second Amendment was ratified looks really, really different than the world that we live in today in a lot of ways. But importantly for our conversation today, it's what life is like for women is really different now than it was back then, and sort of what guns look like today are very different from what they looked like back then as well. So that brings us to Rahimi, which again, the Supreme Court is going to hear oral argument in on November 7th. And it is actually, as I mentioned, the Fifth Circuit Court of Appeals heard Rahimi in March, and was the first federal court that overturned a gun regulation pursuant to Bruin. And so now the Supreme Court is going to be hearing this case. Again, Rahimi comes very quickly on the heels of Bruin. And the thinking is that they're going to use this case to really clarify what they mean when they talk about this new history and tradition test. So very, very briefly on United States versus Rahimi, let me tell you a little bit about Mr. Rahimi, who was subject to a protective order for assaulting and threatening his girlfriend. While that protective order was in place, he went on a bit of a shooting spree here in my home state of Texas, committed about 5 shootings in 5 weeks in the 2020-2021 holiday season, including shooting at a constable, shooting at a Whataburger, shooting at somebody he got into a traffic incident with. So he's really not the type of person that I think most reasonable people would think should have access to a firearm. But when he was arrested for one of those shootings, he challenged the charge that said, hey, you weren't supposed to have a gun because you have this protective order in place. So as I've alluded to, the Fifth Circuit Court of Appeals here in Texas held in March that there was no relevant historical analog, and therefore the federal laws that prohibit domestic violence offenders who have protective orders against them from having guns was unconstitutional, basically saying, look, there's no evidence that there were domestic violence protective orders in the 18th century, or that we were disarming people that had those orders in place. So the case is now heading to the Supreme Court. And it'll be really interesting to see what happens. I will say, if I'm permitted a moment of editorializing here as I close, is that and I think I'm in good company with respect to a lot of legal experts and historians who think that the domestic violence protective order firearm restriction can easily be upheld even with this new Bruin test by analogizing to this idea of dangerous people who for really all of history have been prohibited from possessing firearms. When now Justice Amy Coney Barrett was a lower court judge, she has this wonderful quote that, again, I will quote in its entirety, because she said, history is consistent with common sense. It demonstrates that legislatures have the power to prohibit dangerous people from possessing guns. And I think I wholeheartedly agree that there's a lot of historical precedent for saying dangerous people should not have firearms, and that people who have protective orders entered against them are exactly the type of dangerous people who we don't want to be having firearms. So I'll close there, and again, happy to answer any questions in the Q&A.
Professor Nanasi, thank you so much for that deeply informative talk about both Bruin and its application to the case we're talking about today in United States versus Rahimi. I will turn it over to Dr. Shannon Frederoli.
Thank you, Kelly. And thanks, Natalie, for a great sort of foundation on which to build for this discussion. And thank you all to the audience for taking some time out of your mornings or afternoons to join us here for this very important topic. So my job here is to talk about the evidence, to talk about the research that has informed where we are at with regard to partner violence generally, and with regard to domestic violence protection orders in particular. And so I will do that in 7 minutes. So we know that intimate partner violence is a long-standing threat to the health and well-being of individuals, families, and communities. This is not a question, it's a fact. It's also a fact that guns make violence, particularly partner violence, more deadly. And you can sort of read about some of the details of these studies in the amicus brief that Kelly led for the research, the public health research community that is, I believe, going to be available through this webinar, as well as a recently released article in the Fordham Urban Law Journal that Kelly also led. But to suffice it to say that there's much evidence to illustrate that firearms in the context of partner violence are risky business and not a good idea. So as a public health researcher, when I see a problem, my role is to figure out how a solution can be developed to address that problem. And with regard to interventions that address that deadly nexus of partner violence and firearms, we have a good strategy for reducing this risk, at least for now. As Natalie described, domestic violence protection orders provide people who are experiencing violence with a civil option to ask for help. We know this mechanism does a good job of identifying people who are engaging in some form of partner violence and identifying those who are particularly dangerous. Right, so this isn't akin to a sort of civil suit in which someone has gotten in a car crash. These are people who are violent and demonstrated to be so. And research tells us that. So just a couple of sort of facts that I pulled out of the literature. One study cited that a little more than 80% of women who file for a domestic violence protection order called police at some point in the 6 months prior to looking to the court for help. So again, over 80% of women in this study who were coming to court to request a domestic violence protection order had also engaged police to try to help with regard to the violence that she was experiencing. We also know from research that about half of respondents to domestic violence protection orders have criminal records charges of domestic violence that involve either their current partner or a former partner. So again, this isn't a one-off that we see for people who are respondents to these orders. People who are in the system, have been engaged with the system because of their persistent and continued and oftentimes very serious violence at home. So what we know from the research is that domestic violence protection orders shine a spotlight on those who are behaving violently toward their loved ones and often have been abusive over time, with histories of police and/or justice system involvement. So these are also the facts. And when it comes to domestic violence protection orders, there's another fact that is particularly relevant to our discussion here today, which is this. The best available evidence we have teaches us that state laws that prohibit respondents to domestic violence protection orders from purchasing and possessing guns for the duration of those orders are associated with statistically significant reductions in intimate partner homicides generally and intimate partner homicides with guns. So we don't see a substitution effect, which is oftentimes, one of the things that we hear when we talk about gun prohibitions under domestic violence protection orders. If they don't have a gun, they'll just find some other way to kill the person if they're hell-bent on doing so. Sort of a quote that I heard once from a judge who presides over these cases. What we see from the data is that that simply is not the case. If you remove the gun, most of the time, you'll also remove that risk of fatal violence. So it's important to note as well that what the evidence shows us that these associations between states that have prohibitions on firearm purchase and possession for respondents to domestic violence protection orders, those associations with reductions in partner homicide are even stronger when those laws require respondents to relinquish any firearms they have, when those state laws include dating partners among those who are subject to those restrictions, and when those state laws include ex parte orders for those types of orders that can include gun prohibitions in the mix. So when we look at the population level numbers, domestic violence protection order laws that include gun prohibitions save lives. Said another way, if Rahimi stands, people will die. This is also a fact. So as we get closer to November 7th, when the court will hear oral arguments on Rahimi, it's important that we shine a light on what is known about partner violence, the real risks that exist at the intersection of partner violence and firearms, and that domestic violence protection orders that include prohibitions on firearm purchase and possession save lives. It was the decisions of a few that have placed the protections associated with prohibiting gun access by domestic violence protection order respondents at risk, and the lives of many in great danger. So I remain hopeful that when the Court of Nine decides on this case, they will consider the facts and rule in favor of maintaining the protections that for decades have meant that more people quite literally survive violence at the hands of their partners. So again, thank you for being here. And Kelly, I'll turn things back to you.
Thank you so much, Shannon, for providing us an overview with that incredibly sobering public health research. I want to remind everybody that if you have questions for any of our panelists, please make sure to put those in the Q&A. We'll be reviewing those as they come in, and we'll be asking them at the end in our Q&A session. And now I'd like to hand over the panel to Ruth Glenn.
Hi, everyone. Thank you so much for being here. And of course, to Kelly and company for hosting this very important webinar. And I certainly appreciate and enjoy hearing, if you can call this an enjoyment exercise, from my other panelists. Very informative. My call here today is to shed some light on what we call the real world effects. I am a survivor of domestic violence and firearm violence at that intersection, to which both of these panelists, our previous panelists spoke to, and here to tell you from a real life experience that it is a very dangerous proposition. I was fortunate to have survived it. I was shot 3 times by someone who should not have had a weapon. And in fact, under a protection order, even at that time, he was not supposed to be in possession of a firearm, but went and got another firearm. And though it was long ago, it was part and parcel, part of the reason why we have the protections that we have in place currently, until particularly this ruling from the Fifth Circuit. So I say all of that to say is that we can't emphasize enough the danger that there is when there is someone who's causing harm to somebody that they claim to love, and they have access to a firearm. It increases the danger 500 times. There are many numbers out there, but the increase in danger is severe. But more importantly, I'd like to just briefly talk about what it means to have a firearm and never have it result in lethality or fatality, and how firearms are used as a form of power and control in a relationship in which someone is being abusive. Just knowing that that firearm is present is a control tactic. Firearms are quite often used to threaten, harass, and control victims of domestic violence, and in fact may never ever have the trigger pulled. The most important thing is that when someone has stepped forward as a victim and said, I need a protection order, that can escalate that very behavior to a point where a trigger can be pulled. So the threat is just as real as the potential for lethality and fatality. We also know and recognize that when there is a shooting and it involves domestic violence, I want us to keep a close eye on the fact and a reminder that the community impact, and what I'm talking about is everyone from family and friends, the children involved, the neighbors, the cost, all of those things do not just impact the victim who may have lost her life or may have been harmed. They impact everyone. We saw just since the Rahimi ruling out of the Fifth Circuit that the calls have increased from those 3 states in the Fifth Circuit to the National Domestic Violence Hotline, simply because the fear is real. And I want to note that it's not just survivors calling, it's advocates, because they're very, very concerned about welcoming the best to survivors, knowing that there's a possibility that we may not be able to remove firearms from abusive persons. So it's already having its impact, right? And so I can't even imagine what it might be if for some reason this is not remedied as soon as possible, because we know that it's on hold right now. But if advocates and survivors are already inquiring about what does this mean to them, I can't imagine what it's going to be like in the future. So without further ado, I'll just mention I spoke with a young lady here at our conference last evening. We're currently in the middle of our National Conference on Domestic Violence, and I just have to share this with you. And she did not speak to me directly about Rahimi, but she did speak to me about the fact that she lost her children as a result of firearms, because the firearm was not removed soon enough under protection order. She lost 2 children. So when we're thinking about this in the real world impacts, I want us to think about 2 things. I think we immediately go to lethality and fatality, which are real and important. But I want us to remember the other costs to the harassment, stalking, control, and then what happens to those around the victim of domestic violence who is being targeted, quote unquote, by that firearm. So with that, I will close, and I certainly welcome any questions, as do my esteemed panelists.
Thank you so much, Ruth, for sharing your experience with us and for the experience of your attendee at your conference yesterday. I'm so sorry about that. We have a lot of questions about both the case that's going to be heard in a couple of weeks, but also about domestic violence more generally. So first, I'll start with a question for Natalie. Our attendee asks, could there be a clarification or a change in definition of historical from the Supreme Court?
I would think so, and I hope so, right? I mean, there's already some question as to what do you mean when you say history, right? And the court in Bruin didn't really ever explain what they meant. So I threw out the date of 1791, which is when the Second Amendment was ratified. A lot of people also argue that maybe the actual date that you should be looking at is 1865, which is when the 14th Amendment made the Bill of Rights applicable to the states. And so again, that's a difference of almost 100 years. And you see the history being cited. I mean, everything from the 1400s to the 1970s, right? So there's a broad range of history. And I'm not a historian, so I'm grateful that I think we put in the chat the amicus brief of the historians who weighed in on this case. But the Supreme Court really has never said, and I think certainly Rahimi could be an opportunity for them to clarify exactly what they mean when they say history.
Well, thank you so much for that, Natalie. We've got another question. Shannon and perhaps Natalie, you might want to weigh in as well. Is it likely that the Supreme Court in the post-Bruin environment will take into consideration the very compelling findings on the dangers of guns in domestic violence situations? And I'm going to add on my prerogative as a moderator, should they?
Thanks for the question, Kelly. And I have some mixed feelings about this. My mixed feelings stem from the fact that this is even a question in this day and age. Absolutely, of course, decisions should be informed by the best available evidence. And again, I'm discouraged by the fact that this is even something that we are talking about right now. The amount of effort that goes into providing information about what partner violence looks like, who's affected, interventions such as domestic violence protection orders that prohibit gun purchase and possession, and their effects on the experiences that people experiencing violence have should absolutely always be considered in policy decisions, including court decisions. And I realize that that is a question we were talking about today, but I hope that this is a blip in our history and we go back to embracing the real value that comes from evidence and including research in all policy decisions.
Natalie, is there anything you would like to add to that?
I mean, just briefly, right, which is that I think that as much as nominees to the Supreme Court, every single confirmation hearing that come out and they say, look, I don't have an opinion, I'm here to call balls and strikes, and they come in with this veneer of neutrality. I mean, I think we have seen really, especially in the last few years, how that is just not in fact true, that everybody comes to the court with their own perspective, with their own biases. And, you know, even this idea of, well, we're going to take an originalist framework, that is also a decision. That is a policy decision that they are making, even though it is framed as neutrality, it is in fact not. So, yeah, I mean, I think I agree completely with Shannon that these cases don't exist in a vacuum, and the Constitution doesn't exist in a vacuum, and the impact of research and data and the lives of survivors is really, really critical. Certainly, there were a lot of amicus briefs submitted to the court that attempt to enlighten the justices who are experts in a lot of things, but perhaps not in intimate partner violence or the intersection of intimate partner violence and firearms on this issue. So I sincerely hope that they will take a good hard look at those amicus briefs and really think through exactly what the implications of a decision in either direction might be.
Thank you so much. Ruth, I'm trying to imagine, although I don't want to, the worst happening and the Supreme Court issuing an opinion that strikes down this critically important law. Can you tell us a little bit about what the future of domestic violence prevention work might look like for you in that climate?
I agree, Kelly. It's frightening, actually, really frightening. And particularly for those domestic violence organizations that are community-based, and particularly, and especially for any of the advances, so to speak, that we've made over the last 45 years. And I say 45 because that's how long the National Coalition Against Domestic Violence has been in place. So, you know, I think it opens the door, you know, for other types of what I call chipaways at what we've made as advances in the protection and prevention and interventions of domestic violence. I think all of us have stated how dangerous it is when there's a firearm involved. We've worked really hard over the years to ensure as much safety as we can through protection orders, which are already difficult for survivors. Protection orders are already very difficult for survivors to obtain and to even feel safe enough to obtain. So as you begin to chip away at all of those factors that if I'm seeking a protection order, one of the first things I would like to have or want to have or need to have is the removal of the firearm so that I can feel safe on my journey to safety, right? We know that domestic violence escalates significantly when the abused partner tries to separate. And so when you're saying not only you know, have you stepped out and went and got your protection order, but now there won't be the real protection of removing the firearm. I will also tell you that with what increase we've seen at the National Domestic Violence Hotline in the number of calls, I can't imagine what that's going to look like. And the other real world example is we will probably see more victims stay with their abusive partners because, believe it or not, it might be safer, even though they're getting abused, right? The whole thought that if I step out now and there's no way that I can make sure that this person doesn't have a firearm. Yeah, it's very scary.
Yeah, I couldn't agree more, Ruth. I want to follow up with another question from an attendee because I think it fits so well into what we're talking about right now, which is how can or should advocates be talking to their clients about the possible outcomes in Rahimi, including one none of us want to see?
Yeah. So our suggestion is, of course, until there's a decision, let's not do any more alarm. And it's amazing to me that advocates are paying that close attention, you know, to be able to contact us and say, what are we going to do? But let's say that it does not come out as what is rightfully a protection of domestic violence victims and survivors. We are going to have to make sure they understand the ramifications of that once they seek safety and what it could mean. You know, we have to be transparent with victims and survivors so they can employ. If we can't protect them, then they're going to have to figure out ways to protect themselves. And so we have to be as transparent as possible, letting them know that, you know, you may not be as protected as you once might have been because of this particular ruling. I'm also encouraging advocates across the nation and have really used this opportunity at the conference to let people know that November 7th is the date. And up until then, and even after then, We have to, as advocates of ending domestic violence, let anyone that will listen know the harm that can come from a bad ruling on this.
Kelly, can I jump in here just for a quick second and maybe knock a couple of questions off of our Q&A list? So the first is that the argument is November 7th. We'll probably won't get a decision from the court until late in the summer. They tend to hold off the kind of big blockbuster decisions until the very end of the summer when they start handing decisions down. The other is that, I mentioned this briefly before, is that there's the federal law that prohibits domestic violence offenders who have protective orders from having guns. About half of the states also have comparable laws. And again, the laws vary from state to state. But even here in Texas, we have a state law that has the exact same prohibitions with respect to protective orders, right? As long as a protective order is in place, you're not allowed to have a firearm. So if we have it here in Texas, I think it's worth advocates really looking into their state laws. I'll see if I can quickly find, there's a great link that the Battered Women's Justice Project has that is a good sort of compilation of all the individual state laws. So those state laws, regardless of what the Supreme Court rules, will still be in place this summer. Now, what will happen state by state in terms of repealing those laws or changing those laws, again, I would suspect that they would start pulling those back, but it depends, right? It may look kind of a little bit like we're in this post-Dobbs world in the abortion context where the states will be doing different things. And I think it's just going to open up a new, kind of just a whole new world of seeing what the states decide to do. But I think it is important for survivors to understand that, like, you know, November 7th, like nothing is going to change on November 8th. And if the Supreme Court does find that these laws are unconstitutional sometime in the summer, it may be that there's still those state protections in a lot of states that are still going to apply. So it's complicated.
Well, thank you so much. That answered a lot of the questions that we were receiving in the Q&A. For Shannon, I wanted to ask, there's a question from the Q&A. Are there any examples of states or jurisdictions that ceased limiting firearm possession or purchase for these types of orders and saw increases in intimate partner violence, or the opposite? They added the prohibition and saw decreases in intimate partner violence. A second question is, are there specific examples of adding or removing firearm restrictions to the protective order mix? Can you see a change as a result?
So thanks for that question. A lot packed into that question. I'll do my best to be responsive. So I'm not aware of any studies that have looked at states that have removed the types of protections that we're talking about. I would say that one reason for that is that we generally don't see states moving in that direction. Again, as I think you're hearing from all of us on this panel, these are generally viewed as good common sense laws that, with the exception of a few judges, people really don't have a problem with. So when they are enacted by legislatures, they tend to stay. What we do see is some evidence, and I alluded to this in my brief remarks, what we do see is some evidence that comes from comparisons of states that have more protective laws compared to states with less protective laws. And there are studies that speak to the value of adding gun prohibitions to state laws and what that does in terms of the associated reductions in intimate partner homicide. So what we do see is that when states have in their domestic violence protection order laws provisions that prohibit the purchase and possession of firearms by respondents, we do see statistically significant reductions in intimate partner homicide. So that, quite honestly, is among the most powerful, the most convincing evidence we have in gun violence prevention policy generally, and certainly research on interventions that address that deadly nexus between partner violence and guns. So the evidence is strong, and I don't know of any studies that sort of look at the effect of removing those again, because we just don't see that happening. And Kelly, I think I may have forgot the additional questions that were packed into that question that you posed.
So the last part of that question was, are there specific examples of adding or removing firearm restrictions to the protective order mix? Can you see change as a result?
Yeah, so again, when we those studies that I referenced that look at domestic violence protection orders and the various sort of versions that exist among the states, what we do see is that there are really 3 provisions that stand out as particularly effective. So one provision is state laws that include requirements to relinquish any firearms in possession. So they just don't say you can no longer possess, but they say you need to relinquish and you have 24 hours to do so, and the court's going to follow up to make sure that you did. Those kinds of additional provisions within state domestic violence protection order laws make a difference. Sort of they elevate the impact that we see from those laws. The second type of provision that goes along with these gun prohibitions as part of domestic violence protection orders is looking to make sure that dating partners are included, right? So not just spouses, not just ex-spouses, not just people who have a child in common, but people who are dating. And we know that this is important, particularly in our current era, as women are increasingly delaying marriage. They're dating more. And so those kinds of relationships that in the past might have turned violent in the context of a formal marriage, marriage is being delayed. And so that violence is showing up in a non-marriage setting, in a dating context. And we want to make sure that those people are protected. And we see that play out in the data. And the final component that is very important to include is making sure that states include ex parte orders in those prohibitions for gun purchase and possession. So if, at the time that the person experiencing violence comes into the courtroom, that first order that is issued by the court, that is when, these gun prohibitions should come into play, and the evidence suggests that they are most effective when they do come in at that first stage of the protective order process. So thanks for that question.
Thanks so much, Shannon. I want to provide a little clarifying comment, which is many of you may be aware that as part of the Bipartisan Safer Communities Act, dating partners were included in the definition for misdemeanor crimes of domestic violence, but unfortunately were not included for domestic violence protective orders under federal law. We heard a lot from Professor Nanasi about the fact that these orders do in fact have robust due process protections. On the other side of that, I want to ask Ruth, are there barriers or risks to individuals seeking protective orders? And a second related question is, are they necessary? I think I hear this all the time. Can't we, and particularly from Judge Ho's concurrence in the Fifth Circuit's opinion in Rahimi, can't we just prosecute and incarcerate all these people?
So first of all, thank you so much, Kelly, because I do think it's important to address Judge Ho's response. Because it was very concerning. The first thing I'd like to let everyone, or remind everyone, or let everyone know is that protection orders are not an easy thing to seek and get. And the reason why I say seek is that it takes a certain amount of courage to be able to go forward to the court and say, I need a protection order. And it may mean calling the police, which I've never done before as a victim or survivor of domestic violence, or if I've had, I know that the risks, I've just escalated the violent behavior, right? Secondly, revealing finally, maybe for the first time, what's been occurring to me or happening to me as a result of this person being abusive is very difficult. can be scary, humiliating. You're revealing and talking to people that you don't know about the violence that you've endured. And then thirdly, there's a high bar for a protection order. I would say that, before we talk about how easy they are to come by, I think it's a very difficult thing to come by, because you have to, the judge's responsibility is due process, ensuring protection for the victim, making sure that that what they've been presented warrants a protection order. So to put protection orders in this frivolity lens, in other words, it's just this trivial thing is quite disturbing, because they are very difficult to come by. They are not handed out. Protection orders are also a part of the due process. I'm giving you a protection order for a while to make sure that we've protected you, because that's the key word, protected you, and we're going to keep things moving to make sure that this is appropriate. But for the moment, we want to make sure that you're protected. So the whole idea that they're easy to come by is a fallacy. And secondly, it is a huge risk to the victim that they most of the time seek a protection order, because they know that the behavior will probably escalate as a result.
Thank you so much, Ruth. Before I ask our panelists for their final thoughts, I have one clarifying question for you, Natalie. As you discussed the potential impact of an adverse ruling in Rahimi on the analogous state prohibitions, we have an attendee asking, do you mean that even if our state law mirrors the federal law, if there's a bad ruling, the state law would stand until it is repealed or struck down by state court?
Yeah, I think that's right, because the issue in front of the Supreme Court 2 weeks from now is the specific federal law that has this firearm prohibition, right? So again, a lot will depend. I know this is why people hate lawyers, right? It depends on kind of what the exactly the ruling says. But I think technically, because those state laws are not at issue in this case, they will stand. I think they will quickly fall. But technically, they're not at issue in this case, because they might be different, right? I mean, that's the critical thing, is that the wording is different, the details are different, so it's just, yeah.
Thank you for that. And speaking only for myself, as a fellow lawyer, I do not hate lawyers, and I do not hate the answer, it depends. So as we're closing out this fantastic webinar, I just want to ask each of our panelists for some final thoughts, either on United States versus Rahimi, what lies in the future, or about domestic violence prevention in general. So first, I'll turn to you, Ruth.
I saw the question that asks, what can we do? And I think we've all been very clear that we're not even going to hear for many months, what's been decided. I would challenge us to think about how we can get active in our local community about this particular provision for domestic violence victims and survivors, because it's important. And just because it's with SCOTUS does not mean that we can't have our voices heard at the local level, and hopefully be able to spread the word and talk to our neighbors and talk to our employers about the real fear that we have that this ruling is not going to be a good ruling. We can only do what we can do, right? But I do feel it's important that we not stop, even if the ruling is not in our favor. When I said that this is rollbacks, it frightens me of what the future might be on other types of rollbacks. for victims and survivors of domestic violence. So we've made huge progress with lots of work left to do. Let's not go back, not one step. And in fact, let's take 14 steps forward. So I'm going to make my voice heard anywhere I can, and I encourage everyone else to do the same in any way that's comfortable for them. And with all of the information that all of us are offering, Johns Hopkins and our wonderful lawyer and judge, and use all the resources at your disposal to spread the word.
Thank you, Ruth. Shannon, some final thoughts?
Thanks, Kelly. I'll echo what Ruth had to say. I mean, this issue is far from over, regardless of what the court decides next summer. What I would say is, thanks to the efforts of, organizations and people like Ruth, we are in a very different place in this country and arguably with regard to the world in terms of how we look at domestic violence or partner violence. It is no longer, in my lifetime, I can remember that there were times when domestic violence, it was common to just dismiss it, that the violence that happened behind closed doors was a private matter to be expected. And the idea that we would be having a webinar like this and talking openly about how abhorrent such activities are, and classifying it as violence that is harmful to not just the people who experience it, but to families and communities, really shows just how far we've come. And sometimes what happens with progress is we get a little bit comfortable with the progress that we made. And so one of my hopes, again, regardless of how the court decides, one of my hopes is that we will see a resurgence in the type of advocacy and activity that Ruth described. We can't be complacent with regard to the misogyny that is very real in this country. We can't be complacent about the need to continually advocate for policies and laws and programs and initiatives that take on partner violence head on. And I'm, if it's possible to be optimistic in this environment where so much that we hold dear is being questioned, I am optimistic that we will see a level of activity that we just haven't in recent decades, and that we will really return to a full embrace of rejecting the notion that partner violence, domestic violence has any place in our homes, in our communities.
Thank you, Shannon. Natalie, any final thoughts?
Yeah, and you know what? I'm inspired by my fellow panelists' optimism. And so I'm going to also end on an optimistic streak, which is that, I actually don't think that this is a hard legal call. I think that there is historical precedent, as I mentioned before, for disarming dangerous individuals. I think, as we've all heard today, people who have domestic violence protective orders entered against them are dangerous, and especially if they have a firearm. And so I think that there is a lot of space and there are a lot of opportunities for the court to decide this in a way that retains these critical protections that we have. I quoted Amy Coney Barrett earlier. I will quote Clarence Thomas here in the conclusion, right, who said in Bruin that Bruin does not need to be a regulatory straitjacket. And I think if the court follows that prescription and thinks about this not as, did we have these very narrow protective order protections in place 200 years ago, or as opposed to, did we have broader protections in place for people against dangerous people with guns? I think this case is there's a very easy way for this case to keep these protections in place. And I'm hoping that that's what we end up seeing in a few months.
Well, thank you. We'll hope that the Supreme Court listens to the many, many people, including people on this call, who filed amicus briefs in this case. If not, we are not done. Thank you so much for our esteemed panelists, and thank you for everybody at home listening and watching. Hopefully you'll tell everyone you know about United States versus Rahimi, as well as the risk that armed abusers pose to their loved ones and everyone else. And thank you for hanging on just a couple minutes late.